And in this case, we've got two defendants, Mr. Kendrick and Mr. Stillwell.
And the charges are really complex, but they hinge on proving these predicate offenses, basically previous felonies that lay the groundwork for the current charges.
It's like you need to show a pattern of criminal activity, right?
Right.
And we are back, and we are back. Y'all, go ahead and hit that like button, y'all. We are almost at the jury. The jury almost has this case, y'all. We are tantalizingly close to giving this case to the jury to see what's going to be the fate of SB, Shannon, and then Yak, which is, of course, Diamante Kendrick. Now, what you just heard there, y'all, I created a podcast. Believe it or not, I created a podcast to help you understand everything that has happened yesterday and today. There's two episodes of this podcast, and I'm going to put that at the end because I know some of y'all get kind of squirrely with that. So I'm going to put a timestamp if you want to jump and you want to hear this back and forth podcast so you can hear an explanation to make everything crystal clear, or at least clarify it a lot. Check the timestamp in the description, and you can jump right to the podcast if you like, so you can hear this back and forth and get a much better understanding of everything. But for you who like to dive into the details and listen and watch the court, I'm going to go right into that. You'll be able to watch the court. And if you want to continue to watch and listen to the podcast as well, you can listen to the podcast at the end. Y'all, listen, we're over here. We're on the cutting edge of technology. We're teaching people to get in the legal field. We're educating about the legal field. I'm actually learning a lot as well myself. If you want to rock with me, you want to ride with me, you want to party with me, as I say, and you want to work in the legal field, go to careerparalegal.com, CAREER Paralegal, PARALEGAL.com. Put in your information. We'll get in touch with you, and we'll see if we can work together to get you rocking and rolling in the paralegal field, in the legal field in general, but working as a paralegal or maybe even a legal assistant, just depending. Now, with that said, y'all, no further ado. We're going to go ahead and get right into it. Don't forget to comment, like, subscribe, and let's jump into it.
2.021020, and then presence of the parties right now kind of set out also as separate charges, but I don't know who requested that, but I'm kind of thinking we've already covered what those mean. And it may be that in our overt acts, there's a conspiracy to commit a crime that's an actual allegation, so that I would need to charge it with the overt acts. But do we need to charge separately, or does somebody want that as a separate charge?
You said conspiracy?
Yeah.
And what were the other two?
It's conspiracy, and then there are additional instructions about conspiracy, and then there's the presence, conduct, companionship before and after an alleged offense may be considered by you in determining whether they give rise to an inference of a conspiracy.
I don't think we need any of that.
I mean, I feel like we kind of already explained, here's what conspiracy means within the RICO statute.
I think that's correct. I agree with Mr. Shaw.
Okay, state
No objection, Your Honor.
to taking those out?
Correct.
Okay. All right. So another thing we need to do, now that we just have the 106 possession of a firearm by a convicted felon, that does have a pattern. It's really simple. It's just for possession of a firearm by a convicted felon, the state must prove the defendant possessed a firearm after having been convicted of a felony. And then there's a blank to say these particular things are felonies. So I don't know what the convictions of these two defendants are that have come in right offhand, but I would think that that's what's supposed to get listed in the blank.
I think probably whatever convictions are listed in the indictment as the predicates for the possession of firearms would be the ones that we would list there.
Well,
And
are those convictions for these defendants in? I thought that was the whole.
Yes, Your Honor. So the underlying convictions for at least Mr. Kendrick is in. Your Honor, the underlying conviction for Mr. Stillwell That is the conviction that I was looking for right before the state rested its case. I was going through a folder, it's supposed to be exhibit 34Q. I do not see 34Q inside of the documentation that is sitting there. That's the only exhibit missing. And so we are trying to find 34Q. I believe the court said that
I did.
we could open it up for that, that limited purpose, but that is the exhibit that we've been looking for, which is 34Q, which is the 15SC. I think the last digit ends in 6. I know from this higher indictment.
Have you gotten through all of the evidence?
Not since not since Monday or Tuesday when we tested to determine if it's
Okay. So, all right, you just hadn't checked yet.
Yeah.
Okay. All right, so for Mr. Stillwell, it's the felony that he's charged with in count 52 as having already been convicted of is actually also possession of a firearm by a convicted, 2 counts of possession of a firearm by a convicted felon, a 15 and a 19 SC. Is that your understanding? Okay. Well, that's not charged in this indictment, in this count. So I guess then what we would say there is crazily circular. Possession of a firearm by a convicted felon is a felony. So looking at the possession of a firearm by a convicted felon charge against Mr. Kendrick, one of his alleged prior felonies is also possession of a firearm by a convicted felon, but the other one is possession of a firearm during the commission or attempt to commit certain crimes. Do y'all know what that was specifically? Like, was he specifically charged? Was it just during the commission of a felony, the way it was charged?
Yeah, he was charged in 15 SC 140116 with possession of a firearm during the commission of certain felonies, which would have been participation in criminal street gang activity, conspiracy to commit.
What did he plead to, though? I thought the gang, y'all drop a whole lot of gang counts, it seems like.
No,
So-
in this indictment, he pled the conspiracy to commit a crime, which was aggravated assault. He pled the criminal street gang activity, possession of a firearm during the commission of a felony, theft by receiving stolen property, purchase, possession, or having control of a controlled substance in Schedule 1 or 2, excuse me.
Okay, I'm just going to say possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. Okay. I don't know if there's... So we'll have to figure out what the verdict form is going to look like before we can figure out exactly what we're going to say with regard to how they walk through the verdict form. We also need to take another look at the overt act charges and make sure that everything is included that needs to get included that hasn't otherwise been defined in these main charges. So do y'all have a copy of that you can look at?
Yes, Your Honor.
Okay.
This is the copy Ms. Percival circulated at the end of the day yesterday?
Yes, I don't think it's changed since then.
There have been some slight changes to it.
There are some slight changes.
Do we have the slight changes yet?
No, because we were going through it literally minutes ago. But I can screen share that if that's the easiest way to do it.
I think so.
Okay. Yes.
I may have spoken real quickly. The 3 conspiracy charges
Yes.
you're talking about on 18, I've checked those against what you have in the RICO. The only thing that's in those that's not in the RICO that I think should be part of the conspiracy
Okay.
charge is conduct of the alleged conspirators. That's where it stops in the RICO. I think it'd be appropriate to add the words before and after the commission of the alleged offense, because that's an integral part of the conspiracy charge. Otherwise, I think everything that was in those three charges, you're correct, is captured earlier in the RICO.
Okay. So what are the offenses, though? You know, like, I think we kind of got hung up on that yesterday.
Well, here, that's, we're talking about the RICO conspiracy. That would be the commission of the offense that we're talking about.
I mean, I could just say any alleged offense.
Yes, before and after the commission of any alleged offense, yes. Instead of the,
Yeah.
that makes sense.
Would that work?
Yes, Your Honor.
Would that work for the defense?
Okay with it? Yeah, that's fine, Your Honor.
Okay. All right, so with regard to the overt acts, what I was planning to say after I define overt act, so it'll say overt act means an outward act made in furtherance of a conspiracy. The overt act may but does not have to be a crime in and of itself. I was going to say some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined. Does that work?
Yes.
All right. Have y'all together coalesced on any type of verdict form or?
I think coalesced. No, we have not coalesced on a jury verdict form.
All right.
Coalesced isn't us in the state.
We're maybe closer to congealing than coalescing.
Well, if y'all congealed
Yeah,
on
they
a
have
verdict
it-
form.
Yeah, we've prepared one. We've circulated it to them. They got it this morning, a few minutes ago. We have not had that discussion yet.
The best way to proceed may be to throw it up and then on the screen, and then we can discuss the edits we would like to see.
All right.
That works for Mr. Shart.
It does.
Okay, and I don't know. Are y'all ready to do overt acts? The overt acts definitions? Or no?
We
Yes?
could do that and come back to verdict form, yes.
I mean, we need to do them both.
Okay, any
So-
order the court would like.
It doesn't matter to me.
Over there.
Okay.
Thank you for that command decision, Mr. Shart.
This Persefield is like, y'all are all over the place this morning.
I'm just following what Mr. Smith wants.
Wait, that's all any of us wants.
She had a Christina Weaver expression at that point.
All right, do you have it up on the screen? Okay. All right, do we need, so firearm is a deadly weapon, that needs to get charged, but that isn't like a separate charge, right? I mean, I do think that for these overt acts, it would be helpful to leave like assault as a heading if one of the crimes is assault.
Or maybe, I think assault's in there, Your Honor, because one of the crimes is aggravated assault, so, and for aggravated assault, you need to define assault.
Okay.
So maybe,
Well, if it's only aggravated assault, then let's have, can you switch it to say aggravated assault? And is it aggravated assault with a deadly weapon that's the overt act?
Yes, Your Honor.
All right. Thanks. So that'll be to prove assault. So So I think underneath there, we'll give the definition of assault. A person, or assault means to commit or attempt to commit a violent injury to someone else. All right, does that work the way we have aggravated assault now?
Yes.
And then do we have simple battery, or how is it listed?
There's an aggravated battery harm.
Okay, so that would be the same kind of thing then. Well, I don't know that we need the definition of simple battery, because aggravated battery is kind of its own definition. You have to actually cause bodily harm. So do we have any simple batteries in the overt acts?
No, Your Honor.
Okay. We have terroristic threats.
Yes.
Was it from the person or from the immediate presence? Or do you want both?
That's correct, Your Honor, in terms of that overt act 61 says from the immediate presence.
Okay. All right, and then we have a theft by receiving stolen property.
Yes, Your Honor.
And is it all of those things: receives, disposes of, or retains? Y'all okay if I just say keeps?
Oh, yeah.
Do we need to define receiving? I don't think so. Don't y'all think everybody knows what the word receives means?
I think so.
Okay.
Should we say alleged perpetrator?
Instead of, yeah. Well, are we saying alleged perpetrator?
I thought we were saying alleged perpetrator. Are we not?
It's perpetrator.
Just perpetrator? Okay.
Oops. Can you do a global replace of defendant for perpetrator? And we can get rid of that if there's any reasonable doubt, because that's not relevant for here. All right, possession of a machine gun look okay?
Just, Your Honor, for consistency, excuse me, in theft by receiving, the last paragraph says goods. I think everywhere else it says property. Maybe say property, just to be consistent.
Well, it says goods in
It
the second
says
paragraph,
goods.
too.
That is one of the pattern charges that has not gone through a plain language rewrite yet. So it's all over the place. Yeah, but I mean, we can say property was.
You say goods in the first sentence as well of the second paragraph.
Let's say the pattern says.
Oh, that's okay. I'm sorry. The pattern. You're on.
We okay with this one? All right, possession of a firearm by a convicted felon. I think I'll just lift we already have that defined in our substantive counts, right?
Correct.
All right, so the question is, some of the other acts, crimes, will have been defined already. But for instance, the fact that we have possession of a firearm by a convicted felon in the other acts as well, do Is there a preference for whether it still gets listed in this appendix and just said that's already been defined, or not listed at all?
The state would request to list and to say as previously defined.
Okay. All right.
That makes sense.
Okay. All right, so this one will just say previously defined.
And this will all get cleaned up so it looks kind of the same.
And there'll be some others we have to add in there, I would think, but. So on the possession with intent to distribute, we've got various different substances, I think. Do we want to list all of those that way, or just say the substance?
Yes, I would just say the substance.
Okay. Well, so we'll get that fixed. All right, criminal gang activity. Well, yeah, a bunch of these are already. All right, so that's it that we've got. What else needs to get included from the overt acts?
I'm going through around what I have.
Okay.
1 minute, I'm on.
All right, great, thank you.
Judge, there's a couple in here that don't have a header on them.
Okay.
One of these, sale of marijuana.
Okay.
There's two that are the possession by an inmate.
Oh, okay, I did not,
Sorry, they don't
yes,
have- they don't have
okay,
headers on them.
okay, I see them now. I'll just kind of bold them for now. Are y'all okay with, everybody okay with how those two get defined?
Yes.
Yes, Your Honor. And Your Honor, I had one
Yes.
thought with the consolidating the controlled substances.
Uh-huh.
Could we have one sentence that says, for any of these substances, MDMA, methamphetamine are controlled
Controlled
substances?
substances, sure.
Yes, Your Honor. Thank you.
Can you do that, Laura? Is the defense okay with those two ways that possession of a weapon, possession of a telecommunications device by an inmate are defined?
Give me just one moment, please.
Yeah.
And Your Honor, my list was not exhaustive. Any of the controlled substances like oxycodone that we have, we could just have one sentence with all of those substances, are controlled substances, because each individual one lets the juror know.
Yeah, that's fine.
Okay. Thank you, Your Honor.
I would,
The jail part?
yes.
Yeah.
I think my personal opinion is it should follow the text of the statute a little bit more and be less specific about while incarcerated an inmate in Fulton County Jail.
It's only in Fulton County. Yeah, that one's a little bit. What does it say? At a jail or at a correctional? What does it say? I mean, at a jail? There are all these different definitions. I don't know. Let me pull up if anybody knows. Can give me this.
42,518.
Okay. Can you read what it says? I don't have Lexis up yet. Well, it really says while an inmate.
So I guess it's just for while an inmate.
Okay. Wow, an inmate. I'm happy to say out of jail if y'all want, but.
No, just while an inmate, I think, is fine,
Okay.
Your Honor.
So, question. I would just think possessed and not was found in possession of. thoughts on that? It's kind of what the statute
Yeah.
says.
Whenever, of course, ready.
Yep, we're
think
ready.
I found, so what I believe we are missing, and depends on how we want to do it, is attempted murder,
Okay.
murder, and then conspiracy to commit murder, and conspiracy to possess a telecommunication device by an inmate.
Was that a conspiracy? The last one?
The last one with Mr. Garlington on the phone with Frank Hubert and Quantavious Greer.
Is that charged as one of the overlaps?
Yes, that is count 1, I mean, excuse me, not count, act 1. $179.
So conspiracy to possess a telecommunications device?
Yes.
So we have Your Honor, we have a possession of telecommunications device by inmate and a conspiracy. Because 170 is possession of.
Okay. So conspiracy to possess a telecommunications device by an inmate?
Yes. That's because they were on
Is the conspiracy by the inmate who was trying to possess it, or alleged to be by someone else, like helping them? You know what I'm asking?
Yes, it was helping. They discussed possibly flying the phones in the jail through a drone.
You know,
179.
okay, so that would be then like B1, it's unlawful for any person to procure or give an inmate a telecommunications device, right? So it's a conspiracy to do that, right?
Yes.
So conspiracy to provide right?
Well, conspiracy to.
I mean, the statute is not, the statute's called items prohibited for possession by inmates. And part of what is illegal within there is for another person to obtain, procure, or give an inmate any prohibited item. So how do you want me to say that? Conspiracy to provide a telecommunication device to an inmate?
The problem is they cited a certain section in the overt acts.
Well, how did they say it?
They said in the overt act it says Demekion, Garlington, and Quantavious Greer did unlawfully commit the felony offense of conspiracy to possess a telecommunications device by an inmate.
And then described it as how?
When, while speaking over a cell phone to an incarcerated Fulton County jail inmate, discussed a plan to fly a drone carrying cell phones beyond the guard lines to a window
Okay.
at the Fulton County Jail, in violation of 42-518.
Both of those individuals were out of jail, and they were.
It does. Okay, I understand, but that's not really a conspiracy charge. That's a violation of this statute. But I guess because they didn't actually achieve it, then, okay. Conspiracy to possess a
Or to provide.
well, y'all said possess. Conspiracy to a telecommunications device. All right, I need to say. Y'all can be coming up with language for whatever the next one's going to be.
I think the only two
that it appears will be the attempted murder and the conspiracy to commit murder,
All right, well,
based on what I have.
figure out the language while I'm working on this one.
Okay.
Then so am I going to need to define conspiracy? Or can I just say attempts to? So we're not actually like finding anybody guilty of these things in counts or anything. Y'all tell me.
I agree, Your Honor. I don't think we need to define conspiracy. I think you could just put,
So could I just say a person commits the offense of conspiracy to possess a telecommunications device when that person attempts to provide an unauthorized telecommunications device to an inmate?
Yes.
Okay. That okay with the defense?
When that person,
Attempt to provide an unauthorized telecommunications device or cell phone, I can just say cell phone, to an inmate.
this might be putting the word in the definition, but why wouldn't we put conspires to? Because it's not an
Why
attempt.
wouldn't we put?
It's not an attempt, like,
Okay. I don't have the definition of conspiracy in front of me anymore. I'm happy to say it however way y'all want.
I'm not saying we need to define conspiracy again, but instead of saying when a person attempts to provide a, why wouldn't we just say when a person conspires to?
Well, I guess just because I was taught you never define a word with the word. But
I understand, but to me, we're
we
describing
can, I'm fine with that.
We're describing a crime.
Fine, conspires.
It's just because attempt is another
Fine with me.
legal term.
There.
can we,
Okay, that's fine.
I have the conspiracy charge, so
Okay.
a person commits conspiracy to commit possession of a telecommunication device by an inmate when that person, together with one or more other persons, we're going back to what Mr. Shar just said, though, conspires to commit.
Okay.
Mr. Shar.
A person commits the offense of conspiracy to possess a telecommunications device when that person conspires with someone else to provide an unauthorized cell phone to an inmate. Good with everybody?
That's good.
Oh, yes, Your Honor.
Okay. All right. All right, so then we need,
That's Bob.
we will have listed, are these getting listed in the order in which they come as overt acts ultimately, I guess?
If we can, yes.
Okay. So somewhere we'll already have murder. And then we'll need attempted murder?
It seems to make more sense to put them in alphabetical order just because you don't know if the jury may be going back, jumping
I
around,
don't
but
care. We
whatever.
just need to decide on a way. Yes.
I was going to say for the next attempted murder just to cite the pattern instruction 20110, but I think whether it's chronological from the overt acts or alphabetical, either one is,
Attempted murder ought to come after murder.
yes, Your Honor. And because we define murder, the jury will have already been instructed on it for the counts. When attempted murder comes up in the overt acts, I think all that needs to be defined is just attempt, and then murder is previously defined,
Right. Okay. So we'll define attempt.
which
I
I
like
have
that.
that instruction is simply a person commits criminal attempt to commit insert offense, in this case murder, when with intent to commit, that person performs any act that constitutes a substantial step towards the commission of the crime.
Okay. Where did you get that from? Where could I
Your Honor,
lift that from?
The pattern instruction is 2.01.10.10, attempt statutory definition from the pattern instruction.
01, perfect. Okay.
In Your Honor, the only other attempt I believe we have is the attempted armed robbery, which is Act 5.
I like that one.
But we will be defining armed robbery in these overt acts as well.
I'm sorry, but where person, oh, okay, I was looking at the wrong charge. So I think maybe we just do attempt to commit a crime, and then they can reference it for both of them, right?
Yes, Your Honor.
So we're just doing attempt.
Yeah, I think so, yeah.
That's what I have up.
No, I don't, I was totally doing my own thing. Does that work for y'all? What's on the screen? I think say with intent to commit that crime instead of a crime.
Yes, Your Honor. Stated here.
Yeah. Okay.
And should this be criminal attempt or just attempt?
Probably criminal attempt. All right, so conspiracy to commit murder would sort of be like our conspiracy to have the telecommunications device, right? A person commits. Where is that? Where do you have?
Okay.
Let me see how murders. I mean, we could just say the crime of murder. To cause the death of another person unlawfully and with malice aforethought, or, I mean, is it just, it could be, can you attempt to commit felony murder? I guess. Beats me.
I'm thinking through, Your Honor. I don't think you can.
No? I mean, we don't, do we want to just say murder, or,
Yes, Your Honor.
or do we want to say cause the death of another person unlawfully with malice aforethought?
I think just murder, because we would have already defined
All
murder.
right. Certainly. I think that's fine. Everybody all right with that? The way that's defined?
Yes, sure.
Okay. All right, do we think we have all of the, other than the ones we need to just add and say, you know, this is already defined, we think we have everything?
I sent an email, I apologize. As it relates to aggravated battery, the malice definition is different than the malice for murder, and so it's usually given underneath aggravated battery as it relates to what malice means.
Okay. Is that part of the pattern charge?
It's 2.22.31, Your Honor.
Thank you. I can,
I have it, Judge.
okay. I think just drop the whole thing in there and,
I just dropped it in there.
yeah.
It does, I don't know if it all needs to be.
Do you want that first sentence? Does anybody care if we have that first sentence, or just start with malice in this context means?
I think we can start with malice in this context means.
Except it says maliciously, not malice.
Ah, Yep. Okay, we'll just leave the whole thing. Anything else on these? Okay. All right, I think we better turn to the verdict form then. All right, so I know Ms. Percifield had taken kind of, I think, I don't know even whose it was, but somebody's from yesterday and started working on that. And then I know we've got new proposals from the state and from the defense. Is that right?
For the verdict form, no, I have complaints, but no proposal, but.
I sent some edits in. I have additional edits, but I know I sent one form in with edits.
All right.
But that was prior to the most recent version from the state. Should I just start making some comments? Or?
Okay. This is from the court.
It's, yeah, I mean, it's a draft.
On the last sentence that says list each overt act and or pattern of racketeering activity to which you all agree, I believe that we at least need the word, well, I would like the word unanimously before agree, because the pattern has to be unanimous.
Be yes, no, or how would they?
Honestly, I'm not even looking at it right now. I'm sorry, give me just a minute to.
Yes.
That's.
Yeah, they've got, I mean, there's got to be some way they can agree or disagree with that.
Maybe on the question of
Go ahead.
maybe something like on the question on has the state proven beyond a reasonable doubt that the defendant knowingly, and then so you start out with like on the question or something to that effect, and then the options would be not guilty and guilty.
So, bear with me. The sort of concept that we, I think, settled upon last night was that they needed to be unanimous that there was a pattern of racketeering activity.
There would be a pattern.
That a defendant agreed to having somebody commit a pattern of racketeering activity. So maybe do you agree? Do we want them, I don't know that we want them having to say, I think that as long as they are instructed let me start entirely over. So once we got to the verdict form, I was going to say for count one, the state must prove that the defendant knowingly and willfully agreed to join a conspiracy, understanding that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to either get or keep money or other property or to participate in the enterprise. And the state must prove that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. To be unanimous on this count, you must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. You do not have to be unanimous as to specific acts of racketeering activity. You must also be unanimous that at least one overt act was committed after May 10th, 2017 to further a criminal objective of the conspiracy. And then I guess, if you determine that the state has proven all of this, or if you're unanimous as to all of this, you should note on your verdict form any overt acts that you all agree to.
As well as the pattern of racketeering activity that they unanimously agreed to?
I mean,
Was it a question, or that was a request from me?
Maybe after that first part, which I agreed with and feel that it's an accurate representation of what needs to be proven, that's where we put in the options, you the jury or we the jury find guilty or not guilty or guilty, and then afterwards, if guilty, identify the predicate act. Okay.
Identify the pattern of racketeering activity that you unanimously agreed upon.
And additionally, identify the overact.
After that date.
After that date, act with the S potential. And then
any overt act.
After May
And they don't.
2017.
Well, we could figure out whether they occurred after. I mean, they've been told that if they're going to list any overt act, then they should list any overt act, not just the overt acts after that date. And then we can figure out whether one of them is after that date.
Every one of them in the indictment has a date attached to it.
Okay.
Your Honor, if I may.
And y'all had asked either by act number or otherwise, right?
Well, actually, since yesterday,
Yes.
This is going a little bit in reverse order. But the concern that I expressed yesterday was, I think the phrase at that time was, note on your verdict form any overt acts. And in thinking about that, and given that the court's inclination is to tell the jury that if they find overt acts with all the attached requirements, they should list them, is kind of asking them. I don't know what we're going to get if we just say list it. I don't know how they're going to interpret it. So when we sent a verdict form this morning, what we did was attach a list of all of them with a line they can check and to signal that they find it. And just a brief instruction above that says, please check below every act in furtherance of the conspiracy, which all 12 of you unanimously agree was committed by one or more conspirator. Honestly, I don't think we have to say both all 12 and unanimously. I think either one is fine. And so we would have, I think we just say unanimously agree. But that way we'll know, they know to begin and they know to end. They know to do the entire exercise. There's 190 as of this point in time, I believe. They go through all of them. They check the ones they find if they find it. That way we don't have them quit early and we don't have them kind of create their own form. I'm very concerned about the opportunity for confusion that presents.
Well, if we're going to use any version of that, it needs to say any act And not every act.
I understand, I get that. You're not instructing them that they have to find an act, I understand that. But this will give us the answer. I mean, if they are going to be told to designate, report those acts they find, then I think a form that takes them through all of them we'll get the answer. We'll get their answer to each one.
What are the highlights?
Those are acts that may need to come out.
Y'all haven't decided on those yet.
Yes.
Defense?
If they come out, that would only,
Okay.
that would just, we
All
just
right.
have fewer. That's
I
all,
understand.
But the principle remains the same.
I prefer the proposal that Your Honor was putting forth. If we use the checklist that the state has put forth, I think it needs to say, please check any the overact with the possibility for plural S, if any, which all 12 of you unanimously agree beyond a reasonable doubt was committed by one or more conspirator.
And I also prefer the court's original suggestion over the checklist.
So,
But
Your
if-
Honor, I don't think we need beyond a reasonable doubt again. You've already rejected the idea that we have to put that in everything all
Yeah.
the time. They'll be clearly instructed on that. And then,
I just really don't like the instruction check below every act, because it just indicates that there is at least one.
I
the
agree.
state agrees.
We would
If the
definitely
word is
change
any,
that
we have
language.
no objection. So we can take care of that one. And then I have a little more, but I just wanted to explain that list that we've appended here.
All right,
and
well,
the
I'll
logic behind it.
consider that. Is this in Word form in our folder, Laura?
It's not saved in the folder because it just got sent over this morning.
Okay.
I can save it.
All right. What else, Mr.
The,
Floyd?
Thank you, Your Honor. If we could display the version we had up before, because I don't have a copy of it otherwise.
Well, you can talk about it. I'm looking at it, whether it's
I know.
displayed or
I
not.
just I don't have the words in front of me.
Oh.
In the general premise here, Your Honor, is that I think there's an awful lot in there, and it's.
Oh, I hadn't even looked at what was, honestly, that's just something, yeah, I'm not going to write it like that.
Okay.
It is not, it's going to say count one RICO. Now, I guess it doesn't matter whether they find subsection A or subsection B, as long as they find one of them.
That's correct.
But they all have to agree. But they all have to agree on the same one.
No, they have to agree. They have to agree that.
They have to unanimously agree that it was committed in one of those ways.
But
It could be either or both.
But they all have to it couldn't be 6 on one way, 6 on the other.
I don't know. Does anybody know the answer to that? I mean, it's not like in any kind of an aggravated assault case I've ever said, you've got to pick and tell me, did you think that they were, in reasonable apprehension, or did you think some other way?
You're telling them that they have to find they conspired to violate the statute, and they could have conspired in one or both ways, and you're telling them they have to be unanimous. I don't think we have to tell them they have to be unanimous on everything all the time, just like we don't have to tell them that the proof is beyond a reasonable doubt. That is ultimately my concern, because yesterday we spent a lot of time going over your instruction on and as it's expressed here, the 7 elements of each of these two. And they've got that, and they're going to take it with them out. So re-expressing this in some way here is never going to exactly match that. If it did exactly match it, it would have no purpose. And if it doesn't exactly match it, it opens the door to some confusion.
Do they have to unanimously agree? Assume they only find one. Do they have to unanimously, all 12, say, yes, it was the conspiracy to violate subsection A? Or?
Number one, no case on it. Number two, if they find both, if they're unanimous as to both, it doesn't matter.
I know. That's why I'm asking if they're not.
I understand.
Okay.
I'm thinking it through with
All right.
you, that's all. If they do not find one, if they're not unanimous on one, they would have to be unanimous on the other. If they
Okay.
find both, if they're unanimous on both, it makes no difference. There's nothing more for them to do.
Okay, then I think it has to be listed out as subsection A and subsection B. If everybody agrees, they have to agree, all 12 of them, it's A or it's B.
So it would be, do you find them guilty, not guilty as conspiracy to violate A?
Yeah.
Find them guilty, not guilty
Yeah.
as conspiracy to violate B? We don't object to that.
But I disagree with the state in that I do believe that at least having the word unanimous in there would be helpful to the jury, because I really, talking about confusion, I think the racketeering statute is so complex, just to put the word unanimous in isn't
I
that
hear
big a
you,
deal.
but I'm going to tell them, everything you check on this verdict form, you all 12 have to be unanimous about.
And Your Honor, if you're editing the document now, can we view that? Or
I'm
oh, okay, yeah, we can't view that.
I'm old school writing it down. I don't even know, honestly, which of the documents to use because I don't love any of them. So,
Just to be clear from the state's view, I think if we had the one we had submitted said, count one, we find the jury not guilty or guilty of conspiracy to violate the Racketeering Influence and Corrupt Organization Act. Based
would
on
just
the
say
conversation we just had.
subsection A.
Yeah, and then a second one, subsection B.
Yeah, and they'd both be under count
And
one.
I think you would want to say the jury can find them guilty of
Yeah,
one, both, neither.
yeah, agreed.
So that they don't think their job is done if they just check one because
Yeah.
we want that answer.
All right.
But I think with that and the chart on overts, everything that needs to be known is known.
No, because I think since they have to be unanimous on the pattern of racketeering activity, I think that they need to identify the pattern of racketeering
I
activity.
mean,
I can't disagree more.
I understand both of your positions. I think that I will have them, like the one that Ms. Persfield had displayed first, I think, have to say they are unanimous that a pattern,
That would have been
whatever, however we're going to say it. But I'm not going to have them describe the pattern. I mean, we'll have sufficiently explained it to them. They can just say, yep, we're unanimous.
Okay.
When you asked me over the last couple of days about cases that have used verdict forms that say more than guilty, not guilty, what I've just talked about on behalf of the state, I've never seen one go further than that. Guilty, not guilty, and if there's a question about which predicates or which overts, predicates in a substantive case, overts in a conspiracy case, that's it. I've never seen one that asked any more of a jury than
All right. Well, I think I'm just going to sit with all of the proposed verdict forms and put together something that I think makes sense and then show it to y'all later.
Let me lodge a last complaint
Okay.
before you sit down with them. Also with the states, I don't think I said this, but with the states checklist, I don't know why we would be sending out checklist options for things outside the statute of limitations that can't justify. I mean, we're giving them options to check things that legally cannot support a
Well, if that's
conviction.
all they check and they don't check one that's after May, whatever, then
Okay.
I don't know if I'm going to use the checklist, but if I do, it's going to have everything that goes out. All right, so I will work on a verdict form, thinking about all of the different things we've just talked about. Y'all need to figure out what evidence goes out and what evidence doesn't, because if we're taking, the rest of today and then we're taking tomorrow for y'all to have a work day, once we close and I instruct, I don't want to take 2 hours to figure out the evidence. That needs to go out when they walk out. Y'all understand? Yes. Okay. All right. I'm going to step off and we will be in recess, but y'all stay here and work on all of these various things.
All right, so we've got a really interesting case here.
Yeah.
You've given us like hundreds of pages of legal transcripts
Wow.
from a Arakio case.
Yeah.
It's against Mr. Kendrick and Mr. Stillwell.
Okay.
And the prosecution's trying to prove they're part of this organization called YSL and that they committed a bunch of crimes,
Right.
including some murders
Yeah.
as part of their involvement. So we're going to dive deep into all this
Okay.
and see if we can figure out what's really going on.
All right.
Sounds good.
Sounds good.
All right. So just to kind of set the stage for our listeners,
Yeah.
RKO, that stands for Racketeer Influenced and Corrupt Organizations Act.
Mm-hmm.
And it's basically a tool that law enforcement uses
Yeah.
to go after organized crime,
Right.
like the mafia, drug cartels, that kind of thing.
Exactly.
And in this case, they're saying that YSL is this criminal enterprise
Right.
and that Kendrick and Stillwell were key players.
Gotcha. So we're looking at the transcripts to see how
Yeah.
they're trying to prove that.
Exactly. It's like a puzzle, right?
Yeah.
We've got all these pieces of evidence, arguments, strategies from both sides,
Right.
and we're trying to put it all together
I like it.
to see the bigger picture.
It's going to be interesting to see how they use the evidence.
Right. And the arguments that they're making.
Yeah, because this is a high-profile case.
Oh, absolutely.
And RICO cases, they can be pretty complex.
Yeah, they are. And this one's no exception.
So what jumped out at you when you first looked at these transcripts?
Well, one thing that really struck me is right off the bat, the defense is coming out swinging.
Oh, really?
Yeah. I mean, they're not holding back at all.
Okay.
They're basically saying the prosecution hasn't even laid out their case properly
Interesting.
in the indictment. They're claiming there's this key element missing, especially when it comes to these RICO and Gang Act charges.
Okay.
And they're really hammering on this phrase, knowingly and willfully.
Knowingly and willfully. That's interesting.
Right. So I'm thinking, what does that even mean?
Well, knowingly means that the person was aware of the facts of what they were doing.
Right.
Like they knew they were involved in something illegal.
Gotcha.
And willfully, it means they did it on purpose. They chose to be a part of it.
They weren't forced into it or anything.
Exactly. They had the intent to commit the crime.
Okay. So the defense is saying the prosecution hasn't shown that their clients,
Yeah.
Kendrick and Stillwell, actually knew what they were getting into
Right.
and willingly participated in all this.
That's a pretty big claim.
Yeah, it is. And they're basing this argument
Uh-huh.
on this legal concept called mens rea.
Mens rea. That's a good one.
It's Latin, right?
It is. It literally translates to guilty mind.
Oh, guilty mind.
But in the legal world,
Yeah.
it basically means the mental state that's required
Okay.
for someone to be found guilty of a crime.
So you can't just show that they did something.
Right. You have to prove they
Yeah.
intended to do it.
Like they had a guilty mind.
Exactly.
Okay. So that's what the defense is going for here.
They're saying the prosecution has to prove
Yeah.
Kendrick and Stillwell had the mens rea
The guilty mind.
for these RCO and Gang Act charges.
Makes sense. But what's the prosecution's response to all this?
Well, they're pushing back pretty hard.
Oh, I bet.
They're saying, hold on a second.
Yeah.
We've shown they intended to commit these individual crimes.
Okay.
And that's enough for a RICO conviction.
So they're basically saying proving intent for each separate crime
Yeah.
is enough to show they were knowingly and willfully part of the whole thing.
The whole scheme, yeah.
Okay. But is that how it works?
Well, that's what the court has to decide.
Right.
The defense is also saying the case law
Uh-huh.
that the prosecution is citing
Okay.
doesn't quite apply here.
So it's like a legal tug of war.
Exactly.
The prosecution's pulling one way, the defense is pulling the other,
Right.
and the judge is the referee in the middle,
Yeah.
trying to decide who's got the stronger argument.
And whose interpretation of the law is correct.
Precisely. And on top of that whole knowingly and willfully debate,
Yeah.
the defense is also going after something called overt acts.
Overt acts. Now, those are important.
Not sure those exactly.
So overt acts are basically the specific actions
and-
that the prosecution claims
Mhm.
the defendants took to further the goals
Right.
of this alleged criminal enterprise.
So like concrete examples of
Yeah.
things that they did.
Exactly, like specific incidents of violence,
Okay.
drug deals, whatever it may be.
And the prosecution has to list these overt acts
They do.
in the indictment,
Right.
right, to show
Yeah.
a pattern of activity.
Yeah.
And the defense is saying some of these acts are too old
Oh, interesting.
to be considered. They're saying, hey,
Yeah.
the law has time limits.
Time limits, statutes of limitations.
You can't just go back decades
Yeah, you can't just dredge up anything.
and use that against us.
Right. So the prosecution is trying to use these older actions
Yeah.
to paint this picture of an ongoing criminal enterprise.
Like a historical timeline.
Right. But the defense is saying, nope,
Yeah.
you can't use that old stuff against us.
It's not fair game.
Exactly.
So what's the prosecution's reasoning for bringing up those past actions?
They're trying to show a pattern of behavior.
Okay.
They're drawing a parallel to some of those famous ARCO cases,
Like,
like the mob cases in New York back in the day.
oh, yeah, those big organized crime families.
Exactly.
Gotcha.
They're saying these older acts are critical to show the history
Hmm.
and the ongoing nature of this group's activities.
So it's like they're saying this wasn't just a one-off thing. This
Okay.
has been going on for a while.
Yeah, this is a long-standing pattern of behavior.
Interesting strategy.
Yeah, pretty bold, right?
It is. But let's move away from this legal back and forth for a second.
Okay.
And get into the actual evidence.
Let's do it.
What about the murder of Donovan Thomas?
All right, Donovan Thomas.
What does the prosecution have to prove their case there?
Well, they're presenting a combination of witness statements
Okay.
and physical evidence.
Like,
So you've got Kenneth Copeland and Quindarius Zachary claiming they heard the defendants confessing to the crime,
wow. So they're saying they heard them admit it?
that they overheard these confessions.
Okay.
Then there's the surveillance footage from the barbershop
Okay.
where it all happened,
Right.
and the gas station
Wow.
where the suspects allegedly met beforehand.
So they're trying to place the defendants at the scene of the crime
Right.
with this mix of eyewitness accounts and video evidence.
It's like building a puzzle, you know.
Each piece of evidence is another piece of the puzzle.
Exactly.
They've also got phone records.
Yeah.
They say back up the witness statements.
Right.
And a rental car agreement
Interesting.
linking Mr. Williams,
Okay.
who's an alleged YSL associate,
Uh-huh.
to the car used in the murder.
So they're tying in this associate, Mr. Williams,
Yes.
through the car.
And they're using the phone records to connect all the dots.
Exact.
But is it all adding up?
Is there anything that doesn't quite fit?
Yeah, is there anything that kind of throws a wrench in their theory?
Well, that's what the defense is going to try to argue.
Okay.
For example, Copeland claimed that Mr. Kendrick switched from a Pontiac to an Infiniti at that gas station.
Okay.
But the video,
Yeah.
it doesn't clearly show that happening.
Interesting.
So the defense is going to try to use that
Uh-huh.
to poke holes in Copeland's story.
So right off the bat,
Right away.
there's a potential inconsistency
discrepancy.
that the defense can use to create doubt.
Exactly. To raise questions about the reliability of
Yeah.
the witness testimony.
You got to hand it to them.
Yeah.
They're not letting anything slip by.
They're really scrutinizing every detail.
All right, let's keep going with this true crime puzzle.
Okay, what's next?
What about the murder of Shamal Drinks?
Another murder.
What's the prosecution's case there?
They're building a story
Okay.
based on a bunch of different pieces of evidence.
Okay.
Starting with crime scene photos
All right.
and surveillance footage from the gas station.
Another gas station,
Yeah, it seems like gas stations are popular spots.
apparently.
And also footage from the FedEx location
Yeah.
where the victim was killed.
So they're trying to track his movements
Yeah, they're trying to establish a timeline.
leading up to the murder.
Exactly.
Okay.
They've also got a wiretapped phone call
Oh, wow.
between alleged YSL members.
So they're using audio recordings now, too.
And they claim that phone call implicates the defendants.
Okay.
And it gets even better.
Well, there's more.
They're pulling in ankle monitor data.
Ankle monitor data.
Yep, you heard that right.
Wow, so they're using technology to track his movements.
They are. That puts Mr. Stillwell near the scene of the crime.
That's pretty high tech.
It is. They're really pulling out all the stops here.
What else do they have?
Well, there's a note
Hello?
from Mr. Stillwell's phone that mentions dropping the ops.
Dropping the ops. What does that even mean?
Well, the prosecution claims it's code
Okay.
for targeting rivals.
So basically talking about attacking their enemies.
Exactly.
And then there are these social media posts.
Social media.
Yeah.
Okay.
By Mr. Stillwell and another associate
Uh-huh.
referencing the deaths of YSL associates.
So they're bringing in social media as evidence.
Yeah. I mean, it's pretty common these days, right?
It is, but it's still kind of interesting to see it in a murder case.
Right.
And to top it all off,
There's more.
they're highlighting this fact that Mr. Stillwell rented a white Audi
Okay.
that was seen near the crime scene. And
Right.
apparently he had the windows tinted
Tinted window.
on the very day of the murder.
So they're saying he was trying to hide something,
Potentially. Yeah.
like the identities of the people inside the car.
Exactly.
Okay. So they're painting a picture of a planned attack.
A coordinated attack.
And they're using all this different evidence.
Yeah.
Physical evidence, witness statements, digital footprints
Social media.
to try to back up their story.
It's a pretty compelling case so far.
It is. All right, let's shift gears a bit.
Okay.
And talk about these machine gun and drug charges.
All right. The machine gun and drug charges.
This is where things get a bit tricky
How so?
with this concept of constructive possession.
Constructive possession. That's a legal term of art.
It is. So can you break that down for us?
Sure. Constructive possession basically means
Okay.
that you don't have to physically have something on you
All right.
to be considered in possession of it.
So you could be in trouble,
Yeah,
even if you don't actually have the thing in your hand.
right. The prosecution is arguing that because Mr. Kendrick was at the house
Uh-huh.
where they found the machine gun and drugs,
Right.
and because he ran from the police
Oh.
during the raid,
Yeah.
that shows he knew about the illegal items
Okay.
and was involved.
So they're saying his presence and his actions
Mhm.
indicate guilt.
Exactly.
But doesn't that seem kind of circumstantial?
It does.
Like maybe he was just in the wrong place at the wrong time.
That's what the defense is arguing.
Okay.
They're saying, hold on, Mr. Kendrick was simply a guest in the house.
Right.
There's no concrete proof
Yeah.
that he intended to exercise any control
Over those items.
over those items.
That's
So
a
just
problem.
being there doesn't automatically equal guilt.
Right. But there's more to this story.
What else happened?
When the SWAT team arrived,
Yeah.
the prosecution claims that attempts were made
Oh, really?
to hide some of the items.
To hide the evidence.
Yeah.
That's not a good look.
It's not.
Yeah.
And if they can prove that,
Yeah.
it would definitely strengthen their argument
Right.
that someone in the house knew they had something to hide.
So even the act of trying to conceal evidence could be used against them.
Absolutely. It
Yeah.
goes to their state of mind.
This is fascinating. It's amazing how much we can learn. I know, right?
From these legal transcripts.
It's like a window into the legal process.
But before we go any further,
Yeah.
let's take a step back and recap what we've learned so far,
Okay, good idea.
just to make sure we're all on the same page.
Yeah, let's summarize.
All right, so we've seen the prosecution laying out their case,
Right.
bringing in all this different evidence.
Witnesses, videos, phone records, you name it.
They're really throwing everything they've got at it.
And they're trying to prove that Kendrick and Stillwell
Yeah.
were knowingly and willfully part of this criminal enterprise.
And that their actions directly contributed to these crimes.
It's-
But the defense is fighting back hard.
Oh, yeah?
They're challenging the prosecution's interpretation of the evidence,
Okay.
highlighting inconsistencies,
Mhm.
questioning the reliability of certain witnesses.
They're trying to poke holes in the prosecution's case.
Exactly. And they're also arguing that the prosecution hasn't adequately proven,
Yeah.
knowingly and willfully.
Right, that key phrase. And that some of those overt acts they're trying to use are too old to be admissible.
So they're really making the prosecution work for every inch.
They are.
And this is just the beginning.
I know, right?
There's a lot more to unpack
Oh,
in these transcripts.
We've only just scratched the surface.
You wouldn't believe what else is in this stack of papers.
Oh, I bet it's juicy.
Buckle up, because this legal roller coaster is just getting started.
I'm ready for the ride. This whole idea of constructive possession,
Yeah.
it's tricky
It is.
because it really relies on a lot of circumstantial evidence.
Right.
And you really have to dig into the details to
Right.
see if someone really knew
Yeah.
about those illegal items.
Okay.
Even if they weren't, like, physically holding them.
Right, right. So it sounds like the defense is basically going to argue
Mm.
that the prosecution is just assuming that Kendrick's guilty because he was associated with YSL
Yeah.
and because he was there in the house.
At the scene.
But they haven't actually shown
Right.
that he had anything to do
Directly.
with the guns and the drugs.
Exactly. That he had knowledge and intent to control those items.
Right. It's like they're saying, don't jump to conclusions
Just because he was there.
just because he was there.
Right.
So they're forcing the prosecution
They are.
to prove that direct link,
A direct link.
not just the association.
Yeah, that's just guilt by association.
Should be smart.
It's a classic defense strategy
It is.
to raise those doubts.
Okay, so we've got this battle over constructive possession,
Mm-hmm.
and the defense is doing their best to,
Yeah.
you know,
Chip away.
chip away at the prosecution's case.
At the prosecution's case.
What else is in this
Oh.
mountain of legal paperwork?
There's a lot. There is a lot.
You won't believe this.
What?
The defense is also challenging
What now?
the specific charge
Okay.
used in the indictment.
Especially when it comes to the firearm possession charges.
The firearm possession.
Thence to Mr. Stillwell.
Okay, so what are they saying this time?
This gets into the weeds
Okay.
of the legal statutes
Uh-huh.
because it turns out
Yeah.
there are different levels
Okay.
of firearm possession charges.
Okay.
And the prosecution initially charged Mr. Stillwell under a more serious one.
Oh.
It's called 1611-133.
1611-133.
But they might have messed up.
Wait, what? How do you mess that up?
Well, they left out a crucial element,
Oh.
that specific charge, in the indictment.
So like a wording error.
It could be seen that way.
Wow.
Remember that knowingly and willfully thing
Oh, yeah.
we were talking about earlier? It applies to this charge, too.
Okay.
The defense is arguing
Yeah.
that because that essential element
Yeah.
wasn't included,
Yeah.
the charge itself is flawed
Wow.
and should be thrown out.
So they're saying because of a technicality,
Yeah, essentially.
the whole thing could fall apart.
For this specific charge.
Wow, you got to be kidding me.
But the prosecution's not giving up that easy.
Oh, I bet they're not.
They're trying to pull off
Okay.
this legal maneuver.
Okay.
They're basically saying, okay, fine.
Right.
Even if we can't proceed with the original charge under this code section,
Okay.
there's a similar,
Okay.
less serious charge.
Right.
It's 1611-131.
Okay, different number.
Different number.
Okay.
And they're saying this one
Sure.
covers the same general conduct.
So they're trying to like swap it out.
They are.
The different charge.
Yes.
That's
That might be easier to prove.
Oh, okay.
Because it
okay.
doesn't have that
Yeah.
strict knowingly and willfully requirement.
Interesting. So they're trying to like
Mm.
change the rules
They're trying to
in the middle of the game.
adapt to the situation.
Can they do that?
Well, that's what the judge has to decide.
Okay.
The defense is crying foul,
Oh, I bet.
saying that they prepared their whole defense
Yeah.
based on the original,
Right.
more serious charge.
Right, right.
And they're saying this last minute switch up
Yeah.
puts them at a disadvantage.
Yeah, I can see their point.
It would be like studying for a calculus exam
Exactly.
and then being told you have to take a trigonometry test instead.
Not cool.
Not cool at all.
So it's up to the judge.
The judge is going to have to decide.
Whether the prosecution's switcheroo is allowed.
This whole deep dive.
I know, right?
It's a real eye-opener.
It is.
I'm starting to understand why those courtroom dramas are so popular. There's so much strategy,
So much strategy.
so much suspense.
Intrigue.
Even just reading the transcripts,
Yeah.
like you feel like you're right there
in the courtroom.
in the action.
That's like a game of chess.
It is.
Both sides making these calculated moves.
Yeah.
Trying to anticipate their opponent's next move. You
Yeah.
said it.
And this case, it
Wow.
goes beyond just the legal technicalities.
Oh,
It
absolutely.
really raises these questions
Yeah.
about how we view
Yeah.
group
No,
affiliation,
affiliation.
social media,
Yeah.
and even criminal intent.
Right, because you've got this group
Mm-hmm.
that's expressing themselves
Through music.
Through music.
Through social media.
through their fashion, through their lifestyle.
Their whole persona.
And is that
Yeah.
inherently criminal?
That's the question.
Or is it just creative expression?
Where do you draw the line?
Where do you draw the line?
Yeah.
That's the question.
That's what the jury has to grapple with.
Yeah, you're right.
They have a tough job.
It's not just about deciding
Eh.
whether these two guys are guilty or innocent.
Right.
It's about
Yeah.
how we interpret
Mm-hmm.
group identity.
The power of social media. Free speech in the digital age.
This is big.
It is.
This is much bigger than just this one case.
It could have implications for a lot of future cases.
This could set a precedent
Exactly.
for how we deal with these kinds of issues.
With IRA code charges, with social media evidence.
This whole deep dive.
I know.
It's been incredible.
It has been fascinating.
Like we started with just these dry legal transcripts.
Yeah.
And now it's like we're watching a real life
Yeah.
legal drama
Unfold.
right in front of
There's
us.
intrigue,
Suspense.
twists and turns.
And it's making us think
It makes you think
about the justice system,
about fairness
about due process.
and how it operates in today's world.
Absolutely.
All right. So to recap,
Yeah.
we've seen the prosecution building their case.
Mhm.
They're using all these different types of evidence.
They are.
They're trying to show
Yeah.
that Kendrick and Stillwell were knowingly and willfully part of a criminal enterprise.
A criminal enterprise.
But the defense,
is fighting back.
tooth and nail.
They're challenging
Yeah.
the evidence,
Yeah.
the witnesses, the interpretation of the law,
The very definition
the definition.
of a criminal organization.
And now they're even going after the specific charges
Yeah.
that are being used against their clients.
They're raising those procedural issues.
It's amazing
It is.
how much can hinge on
Yeah.
just a few
Like,
words,
A few words.
a technicality.
The smallest details
Yeah.
can have huge consequences.
It really highlights
It
the
does.
power of legal strategy.
The importance of meticulous legal drafting.
Yeah, you can't just
Yeah.
throw these charges around.
You have to be precise
Yeah.
and follow the rules.
And it makes you realize that the law,
Yeah.
it's not just about these black and white rules.
It's not.
There's a lot of gray area.
There's a lot of nuance.
Interpretation.
Strategy.
And maneuvering.
And that's what makes it
It's so fascinating,
so compelling.
but also so complex.
But also so complex.
And in this case,
Yeah,
the jury has a really tough job
they do.
because they have to sift through all this,
All this evidence.
all these arguments,
Mhm.
and ultimately decide
Yeah.
who they believe.
And what version of the truth
Yeah.
they find most persuasive.
There's so much at stake here.
There is.
Not just for
the defendants.
the defendants,
That's
but for how we handle
yeah.
future cases.
Involving IRCO charges.
Marco charges.
Social media evidence?
This is going to be a case
I think so.
that people are going to be talking about
For years to come.
for years to come.
Yeah.
But let's not get ahead of ourselves.
Okay.
We still have a lot more to cover
We do.
in these transcripts.
We're not done yet.
There's another important argument
There is.
that the defense is raising
Mm-hmm.
that we haven't even touched on yet.
Oh, there's more.
Oh, there's more.
Buckle up. This one's a big one.
Okay, lay it on.
The defense is going after the heart of the RICO charges.
Right.
Saying the prosecution is stretching the definition of a criminal enterprise.
Okay.
Way too far.
So they're basically saying that YSL,
Mm-hmm.
this group the prosecution keeps talking about,
Yeah.
isn't even a real criminal organization.
That's exactly what they're saying.
Wow, that's a bold move.
It is.
So what are they basing that on?
They're arguing that YSL is more of a loose-knit group of friends,
Okay.
a musical collective,
Right.
than some structured criminal enterprise.
So not like the mafia
Not like a traditional hierarchical criminal organization.
with like a boss and underbosses and all that.
Right. They're saying this is more like a
Yeah.
group of guys who make music together.
Okay.
Maybe share some common interests,
Right.
but aren't necessarily involved in any coordinated illegal activities.
So they're saying just because they hang out and call themselves YSL
Right.
doesn't mean they're a mob.
Doesn't mean they're out there
Yeah.
committing crimes together.
Interesting.
They're pointing to the fact that YSL has a public presence.
Okay.
They have a record label.
Right.
And they're arguing that the prosecution
Yeah.
is misinterpreting their music, their
Right.
lyrics,
Right.
their social media posts, their shared identity
Okay.
as evidence of a criminal conspiracy.
So it's like they're saying,
Yeah.
don't confuse art with reality.
Exactly.
Just because they rap about certain things
Mhm.
doesn't mean they're actually doing those things.
Right.
That's a fascinating argument.
It is.
It makes you wonder,
Where is the line?
where is the line between
Yeah.
creative expression
Right.
and criminal intent?
Can you really use someone's rap lyrics
Yeah.
or their Instagram posts?
Against them in court.
That's the question.
That's a tough one.
It is.
And it's being debated right now,
Yeah.
not just in this case.
All over the country.
So we're kind of on the cutting edge of this
Absolutely.
legal and societal issue.
It's tricky because you have the First Amendment
Right.
right to free speech.
Right.
But then you also have the need to hold people accountable,
For their actions.
even if those actions are expressed
Right.
through music or online posts.
So it's a balance.
A delicate balance.
And in this case, the jury has to decide
Yeah.
how much weight to give to that kind of evidence.
Yeah.
That's a lot of pressure.
A lot of responsibility.
They're not just deciding the fate
Yeah.
of these two guys.
But potentially influencing how we think about these issues.
as a society.
Exactly.
Wow.
This deep dive has been quite a journey.
It really have.
We started with a stack of legal transcripts.
Hundreds of pages.
And now it's like we've been in a courtroom,
watching this whole drama unfold.
witnessing the legal arguments.
The strategies.
Is evident.
It's fascinating.
It is.
And it makes you realize
Yeah.
that the law is not just about these abstract principles.
No, it's not.
It's about real people,
Real lives
real lives that are impacted by
these decisions.
decisions.
By the way, we interpret the law.
We've seen the prosecution
Yeah.
trying to build their case
Piece by piece.
using all this evidence
Try and connect the dots.
and prove
Yeah.
that Kendrick and Stillwell were knowingly and willfully.
Part of this criminal enterprise.
But we've also seen the defense
Mm-hmm.
really challenging every single piece of that puzzle,
Raising those doubts.
questioning the witnesses,
The evidence.
the interpretation of the law,
Everything.
and through it all,
Yeah.
we've encountered all these legal concepts,
Mens rea.
overt acts,
Constructive possession.
statutes of limitations.
All these things that play a role in how this case is being argued.
Absolutely.
And ultimately how the jury will decide.
It's a reminder
Of what?
that the legal system,
Yeah.
it's not
Is
perfect.
human.
No, it's not.
It's a human system.
Right.
With all its flaws
And biases.
and imperfections.
But it's the system we have.
It's the best we've got.
And it's important to understand
How it works.
how it works
Its strengths and weaknesses.
so we can all be
Yeah.
more informed citizens,
More engaged.
more engaged in the process.
Exactly.
So as you continue to follow this case,
Mhm.
you'll have a much deeper understanding
Of what's really going on.
of the legal battles being fought,
The evidence.
the arguments,
The stakes.
but more importantly,
Yeah.
you'll be equipped to think critically,
To analyze the information.
to question assumptions,
To form your own opinions.
because that's what it's all about,
it is.
being informed
engaged.
and engaged in the world around us.
Absolutely.
So thank you for joining us
It's been a pleasure.
on this deep dive.
Always a pleasure to be here.
We'll see you next time. All right, so we're back for another deep dive. And today we're looking at something a little different.
Yeah, a bit of a change of pace.
Yeah, it's a courtroom transcript, November 21st, 2024.
Fresh off the presses, practically.
It is. And, at first I thought, court transcripts, how exciting can that be? But this one's actually pretty interesting.
Oh, absolutely. This is no dry legal document.
No, not at all. This is actually a pre-trial meeting. So it's the judge and the attorneys.
We've got Mr. Sharp and Mrs. Percival in this one.
Right, hashing out the jury instructions and the verdict form. It's like they're setting the whole stage for the trial,
Yeah, it's like building the framework.
Yeah.
Before they even bring in the jury.
Exactly. And the case itself, let me tell you, it's a doozy.
Oh, yeah. We're talking ARCO charges here. Racketeer Influenced and Corrupt Organizations Act.
ARCO always sounds so ominous.
Yeah, it brings to mind organized crime, mob bosses, that sort of thing.
Exactly. And in this case, we've got two defendants, Mr. Kendrick and Mr. Stillwell.
And the charges are really complex, but they hinge on proving these predicate offenses, basically previous felonies that lay the groundwork for the current charges.
It's like you need to show a pattern of criminal activity, right?
Right. And that's where things get tricky. Mr. Kendrick, he's got a history. Firearm possession, gang activity, that kind of thing.
So for him, establishing those predicate offenses seems pretty straightforward.
Yeah, potentially. But then you've got Mr. Stillwell.
Yes, Mr. Stillwell.
His case is where things get a little tangled. He's charged with being a felon in possession of a firearm.
Which on its own sounds pretty serious.
Oh, absolutely. But to prove that charge,
They need a prior felony.
and guess what that prior felony is?
Another charge of being a felon in possession of a firearm.
Bingo. It's a little circular, isn't it?
It's like using the same offense to prove itself.
It's one of those legal quirks that makes you scratch your head.
I can see why they're spending so much time on this in the pre-trial meeting,
Hmm.
trying to figure out how to explain this to a jury.
Right, because if the jury doesn't understand the charges.
The whole case could fall apart.
Exactly. It's fascinating to see them trying to untangle this knot before it even gets to trial.
Now, another thing that really jumped out at me in this transcript was the discussion of overt acts. These are actions taken in furtherance of the alleged conspiracy. Basically, steps taken to achieve a criminal goal.
Right, like concrete evidence of them working together.
But here's the thing. The judge kept emphasizing that these overt acts don't actually have to be crimes themselves.
This seems a little counterintuitive, doesn't it?
It does. Like, how can something be part of a criminal conspiracy if it's not even illegal?
Well, it all comes down to intent and context. The act itself might be perfectly legal, but if it's done with the intention of furthering a criminal conspiracy...
Then it becomes part of that larger illegal scheme.
Right, it's about connecting the dots, showing the jury that these actions, however seemingly innocent, were all part of a bigger plan.
So it's like a legal puzzle. Each overt act is a piece, and they all fit together to create the overall picture of the conspiracy.
Exactly. And they go through a whole list of these potential overt acts in the transcript. Aggravated assault,
Aggravated battery,
terroristic threats,
theft by receiving stolen property,
possession of a machine gun even.
machine gun. That sounds serious.
Oh yeah, it definitely adds a whole other layer to this case.
And for each of these potential acts, they spend time defining it, make sure the language is clear.
It's like they're creating a specific vocabulary for the jury to use.
Understand this case.
Exactly. And then it takes a turn. Things get a little, well, I don't know, strange maybe.
Strange how? What happened?
There's this whole discussion about inmates possessing prohibited items, specifically cell phones.
Cell phones.
Yeah, apparently there's an overt act that involves a plan to fly a drone with a cell phone into the Fulton County Jail.
A drone into a jail.
Yep. Sounds like something out of a movie, right?
It does. I mean, how else are you going to get a phone to someone in jail?
I guess that's one way to do it. But it raises all sorts of questions about security and how these new technologies are changing the game.
Right. It's like the law is trying to catch up with technology.
Exactly. And that's what they struggle with in the transcript, is this conspiracy to possess the phone, conspiracy to provide it, or just a straight-up violation of the rule against inmates having phones.
They're really trying to figure out where it fits in the existing legal framework.
It highlights how something as simple as a cell phone can become this complicated legal issue.
And that's just scratching the surface of this transcript. We haven't even gotten to the potential defenses, the evidence.
Oh, there's so much more to unpack.
We got a lot more digging to do.
And it's not just the cell phone thing. It's like every one of these overt acts, they really get into the weeds with the language.
Yeah, I noticed that they were debating the wording for theft by receiving stolen property for ages.
Oh, yeah. I remember that. Receives, disposes of, retains, even just keeps, like every word could change the whole meaning.
It shows you how much weight each word carries in a legal context.
Absolutely. One little change, and the jury might interpret the whole act differently.
It's kind of mind-boggling when you think about it, all this meticulous effort just to make sure the jury instructions are crystal clear.
It makes you realize this isn't just some abstract legal game.
Right. These are real people's lives we're talking about.
Exactly. And the outcome of this case will have real consequences for the defendants, their families, the victims.
Speaking of consequences, the whole discussion about prohibited items in jail really hit home for me.
The cell phones, you mean?
Yeah, we already talked about that drone incident, but that's just one part of it.
It's a whole can of worms, isn't it? Trying to keep contraband out of prisons in the digital age.
I mean, cell phones are everywhere these days. It's not like they were 20 years ago.
It creates a whole new set of challenges for law enforcement.
And for the legal system. Remember how they were wrestling with how to categorize that charge? Providing prohibited items to inmates?
Yeah, is it conspiracy? Is it just a straightforward violation of the statute?
They were going back and forth.
It's almost like the law hasn't quite caught up to the pace of technology.
Like, those statutes were probably written before anyone even imagined drones being used this way.
It's uncharted territory.
It makes you wonder, how do we adapt the legal system to keep up with all this new technology?
Right. Do we constantly update the laws every time a new gadget comes out? Or do we rely on the courts to interpret the existing laws in these new situations?
It's a tough question.
It is. But what's interesting is that they're actually having this conversation. You know, the attorneys and the judge, they're acknowledging that the law has to evolve.
It shows that the legal process isn't stuck in the past.
It's adapting.
It's a living thing.
But for all this talk about legal theory and technology, we shouldn't lose sight of the human element.
Oh, absolutely. At the end of the day, this case is about people.
People who made choices.
Choices that have consequences.
And this pretrial meeting is just one small step in a much bigger process.
It's like we're getting a peek behind the curtain.
But we still don't know the whole story.
There's so much we don't know. What led to these charges in the first place? What's the evidence? What are the defense strategies?
It's like we've been given the first chapter of a book.
And we're dying to know what happens next. It's like we're only seeing the tip of the iceberg, you know?
Yeah, there's this whole hidden world behind this transcript.
All the drama, the motivations, the relationships.
We can only imagine what led up to this point.
But even with this little glimpse, it's fascinating to see how the legal system works behind the scenes.
Yeah, it's not always the high-stakes courtroom battles you see on TV.
It's a lot of meticulous preparation, careful wording, making sure everything is by the book.
It's about due process, you know? Ensuring that everyone gets a fair trial.
And that's what really struck me about this transcript. It's not just about winning or losing.
It's about upholding a system that tries to be fair, even if it's not always perfect.
It's about finding the truth.
And holding people accountable for their actions.
But at the same time, protecting the rights of the accused.
It's a delicate balance.
It really is. So as we wrap up our deep dive into this courtroom drama,
What are your final thoughts?
well, I'm just amazed by the complexity of it all. You know, the legal system, it's like a giant machine.
With all these moving parts.
And every piece is important.
It's a testament to human ingenuity.
And our desire for a just society.
This case, it might just be one small story.
But it raises these big questions about technology, criminal activity, the very nature of justice.
Questions we're all going to have to grapple with as we move forward.
It makes you think, doesn't it?
It does. So to all our listeners out there,
Keep those questions coming.
keep exploring, keep learning.
And remember,
The pursuit of knowledge.
it's a journey best taken together.
This has been The Deep Dive.
Taking you deeper than you ever thought you'd go.
Until next time.
Stay curious.